everybody, and welcome to another discussion board post for History 512. We made it to the very end, so congratulations everybody. I'm really excited to now talk about this newest topic that we have, which is the Bill of Rights and what amendments that we've chosen. My amendment that I've chosen is the 8th Amendment. I just wanted to do something weird and out there because I'm sure everybody's going to do the Second Amendment, the First Amendment, and whatnot. So, the 8th Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And that is essentially that any bail that is set for anybody on trial shall not be excessive and be easily attainable for them. So those words and kind of that 8th Amendment stems directly from the English Bill of Rights in 1689, which states, an excessive bail hath been required of persons committed in criminal crimes or criminal cases to elude the benefit of the laws made for the liberty of the subjects. And so, according to the Heritage Guide of the Constitution, the English Bill of Rights sought to undo practices of judges who levied fines against the king's enemies, thus allowing them to be jailed for non-payment. So not only would you have these excessive fines for these small kind of criminal charges, but then on top of that, you would also be jailed for not being able to pay these excessive fines. And so moving right into the challenges and the complications for this bill. Overall, the amendment saw no complication and no change actually being ratified into the Constitution. Almost every state already had that kind of 8th Amendment already in their Constitution. But what came up is typically everybody has the right to bail except for capital offenses. This is much like the British practice of non-bailable crimes. And LegalDictionary.com states that a capital offense is any criminal charge which is punishable by the death penalty, called a capital. And so these crimes are punishable by death, but they vary state by state, country by country. In some American states, these offenses may be included first-degree murder, premeditated murder for special circumstances, such as unintentional or intentional, multiple involved with another crime, with guns, with a police officer, a repeated offense, rape with additional bodily harm, and the federal crime of treason. A charge of a capital offense usually means no bail will be allowed. And so there are a few court cases that have come up over the years. One of the particular court cases in 1972 was Furman versus Georgia. So in Furman versus Georgia, the court held a 5-4 decision that the 8th Amendment banned the arbitrary infliction of the death penalty, requiring states to rewrite their laws to give judges and juries standards according to which this penalty could be imposed. Essentially, the death penalty was kind of viewed as excessive, viewed as cruel, unusual for some states. We all know that there are most states out there that still use the death penalty. And so in 1972, they required these laws to be rewritten and these judges and juries to know the standards, of course. And in the majority, 3 justices opined that the intent of the clause was to ban arbitrary punishments. 2 other judges rejected the originalist approach to reach the same result. In the main, the majority believed that the penalty had been applied in a discriminatory or arbitrary manner. And so then more applications to modern society was, while excessive bail might have been arbitrary in the past, now it's easily calculated. Um, and we have a lot of modern applications to this amendment, such as Gregg versus Georgia, Estelle versus Gamble, and United States versus Solano in 1987. Gregg versus Georgia was in 1976, and Estelle versus Gamble was in 1976. So that's my post. I hope you guys enjoyed, and have a great day. Bye.